Okay, I think we'll get going and we can always admit anyone else that comes in late. So thank you all for joining us again for another Crone Corkill session. I am Abby Jordan, the director of Crone Corkill, and we are delighted to be working with Mike Pennington's again for another Employment Rights Act update. I'll hand over to Mike, but if anyone has any questions, just let us know. Please do feel free to give us a shout on the chat or follow up with your consultant later and let us know your thoughts and feedback. So over to you, Mike, and give me a shout if you need anything.
Thanks, Abby, and welcome everyone. Good afternoon. Thanks for joining us. So obviously, we're going to be talking this afternoon about the Employment Rights Act and really the roadmap for implementation over the course of this coming year. And really what we need to be doing and concentrating on. Lots and lots of new law coming in. And obviously it was one of the cornerstones of the Labour Party's manifesto to improve life for working people. And they promised, didn't they, when they were elected, to publish their bill within the first 100 days, which they did, October 2024. But it's taken a long, long time, more than a year, for the bill to make all its way through Parliament, and it got royal assent, passed into law at the end of last year on the 18th of December, just before Christmas holidays. And I think there was some, well, obviously massive pressure to get the bill through before the Christmas holidays. And as we'll talk a little bit about later, there involves quite a lot of last minute wrangling on some of the provisions. And the main, the key implementation, their key headline was that unfair dismissal rights would be a day one right for everybody, for all employees. But unfortunately, because of lots of concerns expressed by the House of Lords to that change, the government actually stepped back from that promise, and we'll have a look at but we'll have a look at that a bit later, and the effect of that as a quid pro quo for not having day one unfair dismissal rights, but moving that to 6 months. The House of Lords agreed or conceded that all employees should have unlimited compensation for unfair dismissal claims. So, and that's a really key issue, and something that I think that was decided pretty much at the last minute. Don't know who suggested it, but it actually is going to make an absolutely fundamental change, and probably an even bigger change to employment law landscape going forward than the reduction in unfair dismissal rights from 2 years, as it is currently, to 6 months. There's lots of ongoing consultations going through. And even though these provisions have been made law, a lot of the provisions are going to be introduced formally through what we call statutory instruments, which don't require debates in Parliament. And quite a lot of the provisions there are being consulted on through this year to enable the government to implement their changes in a way that they believe follows through the answers and discussion papers from the consultation. So whilst we can be pretty clear as the timetable of what's coming in and when they're intending to, there might be some slippage depending on how all that works. However, I very much doubt whether there'll be any slippage on the fundamental things and the main points that we'll talk through. So, I mean, for the government, therefore, I mean, Keir Starmer calls it a massive change, and it depends really what side of the political spectrum you're on. The Labour Party believes that working people have been left without basic rights, and that now Keir Starmer says that will end. Kemi Badenoch, on the other hand, thinks it's an adventure playground for lawyers. So not such a bad thing, maybe, for some of us. She's saying new employees are able to start a job in the morning and take their employer to a tribunal in the afternoon. Well, I'm afraid, Kemi, she's slightly misconceived there, because actually it takes quite a long time now these days to get to the employment tribunal. Often, I mean, we're seeing cases being listed for 2 years, sometimes 3 years in the future. So even though there's a huge expansion of employment rights, unfortunately, some employment tribunals are finding it quite difficult to cope with the amount of litigation that's going on. And obviously, with increased rights, presumably comes increased claims, more pressure on the system, and unless or until more resources are thrown at the system, that's going to become difficult. So I'm just admitting some additional people who are just coming on. So let's have a look at the timetable then, and what the timeline is. It started, new provisions came in February, so some things have already come in, and really the timeline runs through to the end of 2027. So we'll have a little talk about what's in store and when. There are some things that I'm not going to talk in great detail about, some very technical changes, particularly to sort of trade union law and trade union rights and strikes and that kind of thing. Suffice it to say that a lot of the changes to this sort of industrial relations law will enable unions far more recognition and far more ability to enable employees to go on strike. So we'll talk about what's in store and when, and obviously top tips. What are the key issues, the key problems that HR professionals are going to encounter, and indeed companies, and how to prepare. And really, we're going to have to start thinking about this and certain aspects of employment pretty soon, before certainly towards the middle of this year, and definitely by the end of the year. In February, there were some trade union reforms. I'm not going to talk too much about this, so just to say that it will become easier for unions to ballot their members. The government has changed and made it less difficult to go on strike. The industrial action ballots going to become easier, and there's more protection coming in against dismissal for taking industrial action. So those reforms have already come in. April, so just gone, the new financial year, on April the 6th, these changes were made. So protective awards for collective redundancies, and these are redundancies that involve 20 or more individuals at any one establishment at the moment. Currently, if an employer fails to consult collectively, i.e. with a union or other appropriate representative, and provide the union or the representatives with sufficient information and consult with them in order to try to avoid redundancy. Currently, a protective award is 90 days pay, so 3 months, and that's now increased to 180 days pay. So something to be aware of if you're going to, or be likely to, or going through collective redundancies. It will pay to get the consultation right. Tribunals start, I mean, this is a punitive award. It's not a compensatory award for an employee who doesn't believe that they feel that they've been consulted properly. It's punitive. So tribunals start at 180 days, or as it is now, 180 days pay, and work backwards and think to themselves, to what extent did the employer follow through a proper collective redundancy consultation? If they didn't do anything at all, the employee will get 180 days pay. If they did part of it, but not all of it, could have done better, it will go down from there. Paternity leave used to be 26 weeks qualifying period. and is now a day one right. And similarly, unpaid parental leave was a 1 year qualifying period and now is a 1 day right from April. Statutory sick pay, no longer a waiting period of 4 days to receive statutory sick pay. And that starts from day one. It's extended to all employees as well, not just those who earn below. So it's extended to those that earn below the low earnings threshold as well. Whistleblowing protection, harassment claims are now, or allegations of harassment are now automatically counted as protected disclosures for whistleblowing protection. It's a bit of a sort of cosmetic change, that, because pretty much any claim of sexual harassment would ordinarily count as a protected disclosure because it would be an allegation of a breach of a legal obligation. But nonetheless, the government have decided to specifically state that sexual harassment allegations are protected disclosures. You will have seen as well in the press that this Fair Work Agency has been introduced. Now, this apparently brings together all the enforcement bodies into one body. And so enforcement bodies like HMRC, Health and Safety Executive, etc., those elements of those bodies which enforce employment action will become the Fair Work Agency, and that Fair Work Agency will have the right to actually bring employment claims where they see employers breaching their obligations. And just to go through that in a bit more detail, the key elements really that I see employers not complying with, which could be enforced by the Fair Work Agency, are things like holiday pay. Holiday pay is a wide-ranging right, and much more wide-ranging than many employers understand, because holiday pay applies to workers, not just employees. So people who are providing their services personally, consultants working on a self-employed basis, for example. In addition, the right to receive holiday pay, or the amount of holiday pay, includes now overtime payments, regular overtime payments, commission payments, elements of pay that employees generally receive on a day-to-day basis. In the past, many employers have simply paid on the basis of basic pay, and I'm seeing a lot of employers who are actually not complying with this, and so this is something that the Fair Work Agency could pick up. Again, I think that there's going to be an issue of resources for that, and so if and when they do start enforcing these things, well, they will probably only do it where they see a wide-ranging, wide-scale, significant breaches. New duty on employers to maintain holiday records for 6 years. And obviously, as I say, the Fair Work Agency can bring claims in place of a worker. And this is a bit of an odd one. Even if a worker doesn't want to bring a claim, the Fair Work Agency will apparently be able to step into their shoes and enforce a claim on behalf of the worker to ensure that the law is upheld. Again, industrial relations issues coming up or have been implemented now. Rules on workplace recognition are changing, becoming much easier much more difficult for employers to resist a workplace recognition claim. I've been involved on one of these in the last couple of years, and it's an onerous process. You have to work very quickly. There is very quick turnaround. You have 10 working days to respond to a request for recognition. and cases can go to something called the Central Arbitration Committee, which will then decide on recognition of a union for consultation on things, collective consultation on things like pay and benefits and that kind of thing. So these rights it's going to be easier for unions who want to gain recognition to do that, and they have to do that with a number of employees who want to be recognized within a bargaining unit. Unions are also going to have a right of access to your workplaces and to request an agreement to access your workplace for the purposes of recruiting employees to become union members, and also to assist employees in their employment issues. And again, if you can't agree, if union requests a right of access, and if you can't agree, then a case will go to the CAC to require enforcement. October this year brings changes to time limits for most employment tribunal claims, which will be extended from the current 3 months to 6 months. And this applies to employees who are dismissed or believe they've been discriminated against, for example. In fact, the time limit is obviously slightly longer because all employees have to seek a conciliation process through ACAS before they're allowed to present their claim, and that operates to stop the clock whilst settlement discussions are ongoing. So it could be quite considerable periods of time, 7 months or so before a dismissed employee is entitled to, or whilst they're entitled to bring their claim. On harassment, now obviously the government the previous government introduced this obligation for employers to take reasonable steps to prevent sexual harassment, and this has been in place now for nearly 18 months. And obviously when that came in, we were required, or all employers required, to take reasonable steps to prevent sexual harassment. How did we do this? Well, you're supposed to do risk assessments, find out what risks there are in the workplace relating to sexual harassment, seek to prevent those risks, obviously have all your policies, undertake training for all staff, and in that way, you're hoping that if someone brings a claim of sexual harassment against the employer, you will be able to show that you've taken reasonable steps to prevent those sorts of claims arising, and then you won't be faced with a potential uplift of compensation of up to 25%. This government is introducing a slight change to the obligation. Instead of just making reasonable steps, you have to now make all reasonable steps, or you will from October. In reality, I think those employers who are already going through significant steps to prevent sexual harassment are unlikely to have to change their practices. However, those that aren't are going to have to double down and really do as much as they possibly can. The risk assessments, the training, and all that kind of thing. It's not just a kind of tick box exercise either. It has to be seen to be real, and that you're acting on things and taking steps. There's going to be also a duty to prevent third-party harassment, and that's not just sexual harassment, any kind of harassment, and that will involve all employers looking at potential areas of their employees' work that they come into contact with third parties. Obviously, most employees will interact with other employees or other organizations or the general public. And it will be important for all employers to take steps to prevent harassment by those people. And this is why, obviously, you've seen, things like signs up at railway stations saying, we don't condone any kind of harassment against our staff and all that kind of thing. That is going to have to be the norm for all employers. And how you do that will depend on how staff interact with other outside agencies. Non-disclosure agreements. Now, this is quite a big one. The government is saying that all agreements which prevent employees disclosing allegations or complaints of discrimination or harassment, any agreement that seeks to prevent such disclosure is going to be unenforceable. And so this applies greatly, really, when there is a complaint of discrimination or harassment and a claim is settled. And ordinarily, you will have in a settlement agreement a form of wording that says, I will keep the allegations confidential, I won't repeat them to anybody, etc., etc. So any agreement that has those sorts of provisions is going to be void. And this applies regardless of whether the alleged perpetrator is the employer or another employee, or whether the complainant is a victim or a witness or whatever. And so, I mean, this is a bit of a double-edged sword. On the one hand, one might think, well, this is a good thing. Why should employers be able to keep these sorts of allegations, particularly if they are valid, outside of the public eye? On the other hand, it's probably going to make employers less inclined to settle claims, even where the employee wants to. And so, a bit because the employee, the employer might think, well, I'd rather go to the tribunal and prove our innocence from these claims as opposed to settling them, because if I do settle them, the employee is just going to be able to go away, take our money, and repeat the claims anyway. So, bit of a double-edged sword, that one, and obviously will have an effect on any kind of settlement agreement going forward. So then, shooting ahead to 2027, we've got the big one, changes to unfair dismissal. We've also got a very big change, what we've called fire and rehire, flexible working changes, changes to guaranteed hours or 0 hours contracts, and a new collective consultation threshold for collective redundancy. We'll deal with those first 4 points separately because they're the key ones. On the collective redundancy side, if you remember, when I was talking about protective awards, I was talking about collective consultation being required where there's more than 20 employees likely to be dismissed at any establishment. And establishment has been defined narrowly, so a site effectively. And that means that employers who have multiple sites but are making more than 20 across all their sites, but none of their sites actually achieve that threshold, they wouldn't have had to have gone through that collective redundancy process. In the future, the government is suggesting that there will be a sort of overarching maximum or minimum, so that if there's lots of establishments and there's a figure, a number across those establishments, let's say 50, then the employer will have to go through collective consultation in that case, even if there are less than 20 at every establishment. So that's going to be a bit of a change. They haven't actually said what the threshold's going to be yet. 2027 as well, there's going to be enhanced protections from dismissal for pregnant women and new mothers. Gender pay gap and menopause action plans will become mandatory. They're voluntary at the moment. a statutory right to bereavement leave, including for those who suffer pregnancy loss before 24 weeks, changes to blacklisting rules and other industrial relations issue, and also regulation of umbrella companies. So those companies that employ lots and lots of self-employed individuals will be more regulated to try to mitigate tax reduction exercises. So the big one then, unfair dismissal. So as I said, originally the plan was to make unfair dismissal rights a new right for everybody from day one, and it's currently 2 years. And obviously that acts as a key buffer for many employers who, if they are dismissing anybody with less than 2 years service, they know that they don't have a claim of unfair dismissal. What we've seen through the years is obviously there's a lot of other rights, employment rights, that are enabled to be exercised by employees with less than 2 years employment. All discrimination rights, for example, the sex, race, disability discrimination, age discrimination, any employee can bring a claim if they've been employed from day one. In addition, employees can currently bring unfair dismissal claims with less than 2 years employment if they're alleging that they're dismissed for a whistleblowing reason or some health and safety reason, etc. So what we tended to see is lots and lots of claims of individuals who may be dismissed with less than 2 years service, but are alleging discrimination and or whistleblowing or whatever, even if they haven't really got very good claims. So the good thing about this is that it's likely to reduce those sorts of claims. However, so as I say, the change, the government trumpeted that this was going to become a day one right, but it's now actually going to be 6 months. So any employee will have a qualifying period of 6 months of employment before they can bring an unfair dismissal claim. As I say, the quid pro quo for that was that it was agreed that there would be a removal of the compensation cap. And currently, unfair dismissal claims are capped at either a year's pay or around £120,000, whichever is lower. So with the removal of that compensation cap, any unfair dismissal claim is going to be potentially unlimited. And this is a massive change. And in particular, it's a massive change for individuals who are earning lots of money and also benefiting from things like long-term incentive plans, share options, big bonuses, etc., because all of those elements of their compensation are going to be claimed for. And if you can think of an employee, a senior employee with all those benefits, potentially running into the millions of pounds over a number of years, and they may well be able to claim huge amounts of compensation, whereas in the past it would have been limited to a year's pay. And this is going to make a massive difference as well to how senior individuals are dismissed, because ordinarily you will have a situation where many employers would think, well, we don't want to go through a performance process with this individual. They're a senior person. Going through a sort of performance improvement plan and targets and all that kind of thing is going to be difficult. They have lots of influence over lots of people. They'll become disgruntled, and you can imagine the scenarios of that being quite difficult. And currently, you might take the view that, well, we'll just sit down with this person. We'll say, let's do a deal. We know that there are limits on the amount of compensation that they can achieve, their notice pay plus an extra £120,000. There's an upper limit. Let's just agree that figure and sign a piece of paper and they're gone. That won't work in the future because the individual will sit there and say, well, actually, no, I've got 3 years worth of LTIPs that are going to mature. Those are worth £500,000. You pay me £500,000 and I'll sign the piece of paper. It's going to be far more difficult to have those kinds of negotiations. In terms of new starters, obviously you've got to think about the probationary period, because if you're going to be terminating individuals at the commencement of their employment, you're going to have to think very carefully and go through a proper probationary period before terminating. And you need to terminate in advance of them achieving that 6 months date. And the reason for that is the next point. The EDT monster, the effective date of termination, is actually extended for the purposes of unfair dismissal. So every employee has a statutory minimum notice period of at least a week. And so if you are dismissing somebody with 5 months and 3 weeks employment, they will actually achieve 6 months employment, because you have to add that extra week on to get to the effective date of termination for the purposes of, have they got 6 months continuous service in order to bring an unfair dismissal claim. So in other words, your probationary periods are going to have to change. If they're currently 6 months, they ought to be reduced. And you need to ensure that management of probationary employees is much tighter. And this may involve obviously training, discussion with managers involved with new recruits and probationary processes. So something to think about for new starters, and potentially changing employment contracts before they start, to ensure that that's covered off. Okay, so that's unfair dismissal. Fire and rehire. Originally, the government was saying that any proposal to terminate or dismiss somebody and for refusing to agree changes to their terms and conditions of employment would be automatically unfair. And that's been watered down slightly, so that the only new right will only apply when the proposed variation is a restricted variation. And a restricted variation is defined in detail, but broadly speaking, it's going to relate to any terms relating to the employee's pay, hours, or holidays. Restrictive variations don't include changes to the employee's place of work or their duties, or to restrictive covenants, etc. So the dismissal for refusing in relation a change to terms and conditions for any of those things won't be automatically unfair, but it will obviously still attract the potential to bring an unfair dismissal claim on ordinary basis. The other issue here to bear in mind is that if an employee is dismissed and replaced by another employee, a non-employee, this will apply. So agency workers coming in to do jobs that were previously done by employees, if an employee hasn't agreed a change to their terms and conditions, that will be an automatically unfair dismissal. So there's quite a lot of things here, and we don't. It's quite difficult to know how this will play out in the tribunals, because obviously we need to wait for tribunal claims to go through the system, so that we know how these provisions are going to be interpreted by the courts. However, it's where we're talking about changes to pay. Pay includes a wide range of things, not just your salary, but bonus schemes, etc. And any employee on a sort of commission scheme that isn't variable, or isn't currently variable, might be able to refuse to agree a change to a future commission scheme for, and quite often these sorts of schemes change based on what someone's selling, or what the business is selling, or how business is working. So you need to make sure that any of those sorts of provisions are variable, that the employer reserves the right to change those sorts of schemes. But even then, we don't quite know how these terms are going to be incorporated or interpreted, rather. The other thing that I think this is going to fundamentally change is dismissals for performance-related reasons. Because if you are dismissing somebody for performance reasons and then hiring somebody else to do their work, to do the same work at a lower level of pay, then it may be open to an employee to say, well, actually, you've contravened these fire and rehire provisions because you've just terminated me in order to hire somebody at a lower level of pay. So again, that's going to be something I think that comes out of these new claims. Changes to flexible working then. Really, this isn't changing a huge amount. What the government has, however, said is that a refusal of a flexible working request has to be reasonable. At the moment, the employer simply has to say that the refusal is based on one of the 8 statutory grounds that exist in the provisions. Ordinarily, of course, we would always advise a refusal currently to be reasonable. But there's no obligation currently in that respect. So it will be important for any flexible working requests that are refused. You have to make sure that actually there's a good reason, a reasonable reason for refusing and it still has to be one of those 8 statutory reasons which are set out in the regulations. Things like the burden of additional costs, detrimental impact on performance, ability to meet customer demand, etc. And then really the other fundamental change is this guaranteed hours proposal. And you'll have remembered the government talking about, ending exploitative 0 hours contracts, perhaps disregarding the fact that many employees actually like the value of the flexibility that 0 hours contracts provides. What the government is proposing is that anyone on a low hours contract, including 0 hours contracts, or below an hours threshold, or a regular hours contract, but below a threshold of hours, will have the right to move to a guaranteed hours contracts. And how they're proposing that this works is that everybody on such a contract will have what they call a reference period. So that reference period, we anticipate, and this hasn't been completely set out yet, we anticipate that it's going to be a 12-week period. And at the end of that 12-week period, employers are going to have to offer a guaranteed hours contract of an average of the hours that they worked during that 12-week reference period. And of course, this kind of sort of disregards the fact that 0 hours contracts are by their nature flexible, and therefore have to deal with perhaps changes in demand. And a lot of these contracts are obviously in the hospitality sector. And how will that work? Well, it's going to be very difficult. And if you can imagine, you're taking on employees all the time. Each one of them will have a different reference period. If you're taking on 3 employees 1 week and 4 employees the following week, you've already got then 7 employees, all with different reference periods, all of whom you're going to have to write to at the end of their 12-week period to offer them a guaranteed hours contract. It's going to be administratively hugely burdensome. There's lots of additional provisions written in, like you can't terminate employees because they're about to achieve a guaranteed hours contract. You can't treat them detrimentally for trying to enforce their rights on this, etc., etc. I mean, importantly, they don't have to agree the guaranteed hours contract that you offer them, but nonetheless, I can see this being a very, very difficult thing for employers to cope with, particularly those who have lots of individuals working variable hours. To conclude then, and a few top tips, review contracts and handbooks, and really the key takeaways here are going to be, probation periods, that 6 month right to bring an unfair dismissal claim. If employees are not passing their probation, you need to terminate before they achieve that period, bearing in mind the effective date of termination as well. It's also worth bearing in mind, and this is this is going to come into play on the 1st of January 2027. So any employee that commences employment after the 1st of July this year will achieve 6 months on the 1st of January 2027. And therefore, as of that date, they will get the right not to be unfairly dismissed. So this, if you are needing to make changes to contracts, handbooks, probationary policies, etc., you need to do that before people are taken on with contracts starting on the 1st of July. Flexible working requests obviously need to make sure that those are reasonably dealt with. Sexual harassment reviews and DEI training, absolutely carry on doing that if you are doing it already. If you're not doing it already, you need to get cracking with it because of the changes to sexual harassment law becoming even more stringent. The government has in fact said that sometime in 2027 they are going to be providing guidance as to what reasonable steps means in the context of preventing sexual harassment. Obviously that's 2027. This change is coming in this year, so it's a little bit late, but I mean, we do know what steps ought to be taken, and if anyone would like some guidance on that, please do let me know. Have a look at bonus commission arrangements. It's going to be important with the hire and refire provisions to try to make sure that any arrangements that you've got there are not contractually binding for future years, and that you can change them. And reviewing 0 hours contracts, really have a careful think about whether you do need them, because when these new provisions come in next year, it's going to be very administratively burdensome for you. We'll share the slide. I'll ask Abby to share the slides to everybody afterwards. And there's just a little link there to our website. We do have a sort of dedicated page on the Employment Rights Act when things are coming in, and some useful commentary for you if you want to have a look at that. And that's obviously my email address and phone number, contact details. If anyone would like to call or email me after today's session, I'd be more than happy to answer any questions that you have. But also, if anyone's got any questions now, I'll be delighted to try to answer them. I'm not sure I can access the chat box, but if anyone wants to put
I've got it up here, Mike, just in case.
Questions in the chat box, I'm very happy to answer.
What we'll do, like Mike said, we can circulate this recording and any contact information that Mike has shared, so you can follow up if need be. We've also got another session, haven't we, Mike, on the 30th? So if anyone wants to recommend this to anyone else, any other colleagues that couldn't make today's date, then please do share that. Obviously, feedback is welcome, isn't it? So always like to know what people want to hear about, or any tips and hints that they want to have a follow-up on. So just going to have a quick look just to see. There isn't any questions from what I can see here, but as I said, we can always do a follow-up, Mike, can't we? And anyone can ask any questions, we'll fire them over to you. So yes.
No worries. Okay.
Perfect. Well, thank you, Mike. I really appreciate your time, and obviously we look forward to seeing you in a couple of weeks' time. Thank you for joining us, everyone. And if you have anything, please do reach out to your consultant, and we'll do the follow-up with all of Mike's details and info again. So have a good rest of your day, everyone.